We will stand for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Please be seated. And I'll note for the record that our board members are here and Ms. Sticken is on her way. So we will begin as we have a quorum. I move the approval of the minutes of the August 18th, 2025 board meeting.
Second.
Second by Mr. McCafferty. Any unreadiness? Hearing none, all in favor, aye. Aye. The ayes have it. Thank you. And I move to acknowledge Secretary of State Directive 2025-49.
Second.
Second by Mr. McCafferty. Any unreadiness? Hearing none, all in favor, aye. Aye. The ayes have it. I move to acknowledge Secretary of State Directive 2025-50. Second by Mr. McCafferty. Any unreadiness? Hearing none, all in favor, aye. Aye. And I move to acknowledge Secretary of State Directive 2025-02.
Second.
Second by Ms. Stewart. Any unreadiness? Hearing none, all in favor, aye. Aye. The ayes have it. And our 1803 Superior Avenue facility update, the chair recognizes Deputy Director Gallagher. Good morning.
Good morning. Before we go further with it, I wanted to give you a little recap on the discussion of the rainwater and damage to the Agilis machine. A recap from our last meeting. I'll give you an update as far as what happened since then, and then our recommendations with it. At the last board meeting on August 18th, I updated you on the issues that we have had with rainwater entering the parking garage in general, and more specifically, water entering the condition space that houses all of our vote-by-mail processing. I further reported to you how the rainwater and some cement flakes fell from a cement beam over the machines and caused damage to one of the sensors and multiple control arms on the Agilis vote-by-mail ballot processing machine. We do have two Agilis machines. Both units work together and as redundancy in case one goes down. For those who do not know, the machine not only sorts the vote-by-mail envelopes into municipalities and precincts, but it captures the voter's signature ID information, which is used for verification processes. The water and cement flakes that caused damage to one of those units it caused the entire line to become inoperable for much of the September election. Rumbeck Election Services, who sells and maintains the machines, notified us that the only way to assess the true damage to the unit and conduct needed repairs was to remove that stacker unit and ship it back to the manufacturer so that they can do a complete diagnostics and assess and repair the damage. The estimate for that repair and diagnostics is somewhere between $20,000 and $26,000, including shipping. At that time, Director Perlotti and I ordered 2 carport tents to be purchased from a home improvement store and installed to better protect and cover those Agilis machines and prevent further damage. So now the update. Well, 2 days after that previous board meeting on August 20th, we had a strong rainstorm in Cleveland, in which we saw rainwater come down into the garage in areas that we had not seen before. A large pool of water gathered underneath the mail sorting hub and several other areas, both machines, around both machines. And just to put into perspective, one of those sorting hubs cost $250,000 each. Fortunately, there was no visible damage to either one of those. At this point, we had seen enough, and we made the request to Public Works to work together with us to move the entire vote-by-mail operations out of the garage space and into the main building. We met with Director Mike Dever and Project Manager Paul Sternum, and together we walked the garage space, and together we determined that the best short-term solution was to contact Rumbeck Election Services and have them move both Agilis machines to the north end of the garage, away from the area where we had seen the leaks. The absentee department continued operations with one workaround and with one machine, and continued to operations for processing the September election vote by mail ballots. On Friday, August 29th, the Friday right before Labor Day, staff began having problems with the one Agilis machine that was still working. That stacker also was under, in line with that cement beam that was releasing cement flakes and water and debris. Although and at this point, we suspect that some of that debris had fallen previously and worked its way in and caused, and then the damage to that unit became evident at that time. Absentee staff were able to come up with some workarounds and then some additional workarounds when the first workarounds failed. So, but again, they continued processing and working together to get the job done. So where do we stand? We have made arrangements with Rumbeck Election Services to come on September 15th. They will come and move both Agilis machines to the north end of the garage and will replace the damaged rods. So many of the rods, maybe about 7 of them, have rust on them as well. And they all stem mostly from underneath that beam and then further out from there. They will also work to repair the Agilis machine that started acting up right before Labor Day. And that visit alone will cost us maybe up to $6,700. They will also set aside that first damage stacker that will need to be shipped back to the manufacturer and would cost the additional $26,000, as I said. The director and I will weigh out which makes the most, what options and what we should do in the short term as well as the long term. And there will be something coming forward later after this. With regard to the garage, a new plumber company was hired and they discovered that the original company had left one of the drain caps off, which caused a leak, but that wasn't here and it wasn't near the Agilis machine. The major issue is with the seams in that garage that were supposed to be watertight. Those seams we went up and we inspected them as well, and they said that those seams were not properly installed, and we could step on them and we could see that there was leaking coming from that. Since then, the contractor has removed the seams, and we don't know exactly with the fall weather and stuff how ideal this time of year is to repair those seams. The county law department has sent letters to the landlord regarding the situation. The landlord is pointing fingers at the waterproofing company. The waterproofing company is saying that the product failed, and the product manufacturer is saying it was improperly installed. So now Public Works believes that our best course of action moving forward is to force the landlord to live up to his obligation and make the garage watertight, as they should. But we believe that although they may be able to achieve a reasonable dryness in the garage, it will not reach the level that's required for that $1 million sophisticated computer equipment like the Agilis. It has not only computer systems, it also has sensors, pulleys, belts, control rods, things like that, that all must work in harmony along with moving the paper in order to properly process the voters' ballots. I'll just say you can't park a Jaguar in a barn. You can't not take care of the equipment the way that you should. So Director Prelati and I have looked for options for bringing the equipment into this building. There's a large space over on this side of the building that currently is being targeted to be used as a general multi-purpose meeting place for the county. But it would make a perfect place to house both Agilis machines. It will require minimal build out. It has concrete floors that can sustain the weight of the equipment. It also helps resolve one of the issues as far as providing backup power for our vote by mail process, because this building contains what is called hospital grade backup power. So this way, the expense that would be needed to add backup power to the garage won't be needed. Operationally, it also allows us to consolidate our work in this building. So the BOE would be able to come out completely from the garage. In this consolidated space, we would be able to actually use some of the bullpen area that's really targeted to be used during state petitions and provisionals. But the way that operations would work out, we would be able to use those computers in that area as part of the vote by mail process. And by us being out of the garage, it also gives the gives the landlord and the vendor proper time to be able to repair that garage correctly. Now, once that garage space is repaired correctly, it can be purposed for other county uses and other county needs that aren't housing an Agilis vote by mail processing machine. We believe this is a good time to change. At this point, right now, we can go with a short-term solution, but have all our operations in place for next year. On the bright side, the September election was a small election, and we had time and margins to work with and to make adjustments. We will not have those same margins in the November general election or next year's gubernatorial primary and general election. We have $1 million of equipment in that room, but the damages so far are only a fraction of that cost. And also most importantly, not one ballot was damaged, not one voter was disenfranchised, and we were fortunate for this election, but we don't want to risk it going forward. So Public Works had said that they would work with us to explore these options. We believe that this is the one and only option going forward. Thank you.
Thank you, Deputy Director. Any comments from the Director?
Yes, Chairman, just to build upon a little bit of what Deputy Director Gallagher said. First off, we did hear you at the last meeting, and we did invite someone from Public Works Administration to be here today, and they had confirmed that they would be. I do not know. I don't know if anyone is here from Public Works. I don't see anyone. So I'm not sure what happened there. But I agree with everything that Deputy Director Gallagher said. And what I'm looking for is the first part of this lease is 17 years. I want a 17-year solution. Can't work for a little bit and then go bad. That structure hasn't been put to the test. It hasn't had hundreds and hundreds of cars, thousands and thousands of pounds put on all that concrete. There's a lot of water that's in that concrete in between the layers because it won't rain and water drips for days. And we know it can get a little bit cold here in Cleveland, and with freeze thaw, we know what that does to roads with potholes. I'm assuming you'd have a similar type of situation in the garage structure. So it's just a lot of this comes down to risk. What's the risk tolerance of the ballots of the people of this county? We are the leader in vote by mail in the state, have been for over a decade, and will continue to be that. So the inside solution is a good solution. We have gone through, we've modified, and we've come up where there is a possibility for us to move into this building to not disrupt any of the health and human services space planning programming that was created. So that all goes forward as is. And the two spots that we're looking to utilize really aren't part of the plan right now. It's still in this, the county trying to figure out exactly what to do, and we have figured out a way what to do. So the backup power, the shrinking of our overall square footage, which reduces our rent and is a savings to the county, is good. It's more efficient. We can get more done quicker being in the one location. And it is peace of mind when every time it rains, coming in and the first thing you do is you run into the garage to see, are we good? Shouldn't have to do that. And there's a way, I think, to minimize that. So we will continue to talk with the county and see what we can do to have this solution. The solution that we're proposing, we know that that wouldn't be in place for November, and we'll handle November and do what we can, but would want something in place for the statewide federal election, state elections that happens in May of next year. So we will push to see what we can do to make that happen. Again, we've come up, Deputy Director Gallagher, myself, and working with Manager Becky Brake, how we can make all this work and what we have. So as always, we'll keep you updated. And when we need you to attend meetings, we'll let you know, and we'll do all those things.
Okay, we thank you both for your work on this matter. Board members, any questions that you have for the director or deputy director? Okay, and as we mentioned, Director Perlotti, that we did invite Public Works, and the chair will acknowledge anyone in the audience from Public Works. If you are here representing the county, you are recognized to speak to this issue. Okay, seeing none, they're not. Board members, any questions or comments to the director on item 5?
One question, Chairman. If one of the options proposed of moving all the equipment inside the building were to happen, what's the deadline we need for that?
I would like to, it'd be nice to have everything in place March 1st of 2026. And then what that allows us to do is the opening of absentee voting for the May election will be in April. Cuyahoga will come a little bit before that, and this department is responsible for that, and allows us to, they'll get the equipment in, make sure everything is logic and accuracy tested, fine-tuned, and then Manager Brake and her team will work through the logistics actually of being in a new space. While it will be better, it'll be more efficient, it is still something to learn. So I think March 1st gives us that runway to be able to do what we need to do to be successful. Of course, sooner than that is always appreciated, but also trying to be realistic in the amount of time that it takes to get something done. That's what we would like to see.
Thank you.
Thank you. Anything else? Now, item 5 takes us right into item 6, where we have requests for authorization for the director and deputy director to undertake all actions necessary to procure the equipment, component, and/or service necessary to support and maintain both Agilus systems. So I support that. So I do move to authorize the director and deputy director. Is there a second?
Second.
Second, any unreadiness or any comments on that?
Chairman,
Yes.
if I could, I just want to, regarding, of course, we're always going to do what it takes. Some of these things are going to be costly, and there are, rules on what we can, what the board needs to approve. So some of these things may exceed that threshold, and we will bring that back, and we will be transparent. One thing that Deputy Director Gallagher had mentioned was looking into the potential of refurbishing the damaged equipment that we have versus purchasing new. And one of the things that we will consider as we go forward is functionality for the November election. Because one item, for example, a purchase of a new piece of equipment could be here in place in time to use for November. The refurbishing, I can't guarantee that. And with how the second machine came out of operation somewhere down the road, what that leaves is we're going old school with a little hand scanner trying to do what you need to do. And when the volume just goes up exponentially in a countywide election, that's really not ideal. So potentially you could, a few $1,000s that you may save on a refurbish, you will quickly eat up in additional seasonal employees, overtime wages, and all that would actually could cost you more money in the end. So first and foremost, it is what are our options and able to execute both machines on day one of the opening of absentee voting for the November thing. And we'll have those discussions. And maybe it is repair, but also might be replace. And so I just want to make sure everyone is clear we have to make this decision probably by the end of this week in order to make things happen. But I appreciate the board trusting Tony and I to do our due diligence and to come up with the best solution for this agency.
Thank you. The motion is on the floor. But board members, any other comments?
Mr. Chairman,
Yes, sir.
to the director, are both machines the same age?
No.
Seems to me one was,
We obtained our first machine, I want to say, in the beginning of 2020. And I think we used it for the first time in the 2020 general election. And from that time, we had built on, you have the brains of the system, the transport unit, and you have the stacker units. And so we purchased some additional stackers as we went along the path. But as we were in the last budget cycle and coming into the 2024 presidential, we got authority to get a second unit so we could have redundancy and improve our efficiencies. And so that other machine came in 2024. And it just so happens that some of the parts here that have been damaged are from the unit that is about a year old.
newer.
Yeah, yes. So the machines run great when they're in the correct environment. And we found out when they're not in the correct environment, yeah, it's not good.
Thank you. Anything else from the board? All right, the business is before us. All in favor, aye?
Aye.
Aye. The ayes have it. So ordered. Thank you so much. And on to candidate and petition services. I move to acknowledge the following appointment to elected office, and that is Gerald Horning, Bay Village City Council, Ward 1.
Second.
Second by Mr. McCafferty. All in favor, aye? Aye, the ayes have it. And on to acknowledgement of candidate withdrawals from the November 4th, 2025 general election. These following candidates have withdrawn: Johanna Hamrick, Berea Ward 3 Council; Ray Tarasuk, Cleveland Municipal Court Judge, unexpired term ending January 1st, 2028; Zachary Robach, Lakewood Board of Education; and Richard Henry, Olmsted Falls Board of Education.
Second.
Second by Mr. McCafferty. All in favor, aye.
Aye.
Aye, the ayes have it. And the chair recognizes Mr. Brent Lawler. Good morning.
Manager, Brent Lawler, Manager, Candidate Petition Services. Richmond Heights Mayor Kim Thomas filed a protest against candidate Alex Harper, who's running for Richmond Heights Council at Large. The initial protest indicates that Mr. Harper has not met the conditions for restoration to hold an elected office because he is convicted of 2 federal felony offenses and has not received a reversal, annulment, or full pardon of the convictions. She supplemented that protest after the initial protest deadline with a letter further protesting, indicating that he is incompetent to circulate or serve as a witness for the signing of any declaration of candidacy petitions. Those are the 2 protests. You have Mr. Harper's response, and you have Mr. Munson's legal opinion.
Thank you, Mr. Lawler. Board members, anything for Mr. Lawler? Thank you for teeing that up for us, sir. And the chair recognizes Mr. Mark Mussa.
Thank you, Mr. Chairman and board members. As Mr. Lawler stated, the protest filed on August 21st objects to Mr. Harper's candidacy based on federal felony convictions, disqualifying him from taking office. However, disqualification from taking office does not disqualify a candidacy. Under Ohio Supreme Court decisions, State ex rel. Vanna versus Maple Heights, a candidate for public office need not be qualified in order to run for that office, but must remove any disqualifications immediately upon assuming office. So the protest filed on the 21st, alleging that Mr. Harper is not competent to assume the office that he's running for, does not necessarily preclude him from standing as a candidate for that office. It's 2 separate matters. The supplemental protest filed on the 27th, challenging the petitions that Mr. Harper circulated himself, despite his federal felonies disqualifying him as a circulator. There's a question over whether or not that's properly before the board. The 74-day deadline prior to the election on filing protests requires the written protest to contain specific objections to constitute a protest. The protest filed on the 22nd, naming the specific objections regarding Mr. Harper's qualifications to assume office, was timely filed by the deadline that expired on August 22nd. The supplemental protest filed on August 27th was filed after the deadline. So the question becomes, as a threshold matter, whether the board has jurisdiction to consider the specific objections raised in the August 27th supplemental protest. Now, the Supreme Court has said that the statutory requirement to name specific objections is to provide notice to the potential candidate. So the question I think the board needs to determine, and it has some discretion here, whether or not the supplemental protest based on the same felony convictions that the timely filed protest raised is the same protest, or is that different specific objections raised after the deadline and therefore an untimely protest against Mr. Harper's candidacy. The Supreme Court has said to determine whether or not that the specific objections are new or continuation of the timely one is whether or not the evidence that supports that objection is the same or if it requires additional information. And I think based on the first protest was Mr. Harper's disqualification from office. He's a convicted federal felon and can't assume an office of public trust. That's one piece of evidence. But to disqualify his petitions based on his incompetency to circulate petitions will require the board to look at the petitions that remain after striking the petitions, the part petitions that Mr. Harper circulated to determine whether or not he met the 50 signature threshold. So I think the board is within its discretion to limit the hearing protest to the objections raised in the 21st letter and disregard the objections raised in the 27th letter. However, if the board does determine this is just one continuation of the same protest based on the disqualifications due to his federal felonies, the board can proceed within its discretion, I believe, to entertain the arguments raised in the 27th letter contesting Mr. Harper's competency to circulate petitions and examine whether or not he filed sufficient signatures to qualify him for the ballot.
Thank you, Mr. Musson. Board members, any questions for Mr. Musson? Yes.
Just looking at the Ohio case law, I think it's pretty clear.
Right. Right.
When you assume the office. So I just want to make sure that's strict, because that's kind of an important distinction for purposes of this. So that would be if someone wins and this is an issue to be revisited, not at this moment.
Correct. There is a window of time between election day and the term commencing where he could purge himself of the disqualification.
I saw that case law. So there could be a situation where someone between running and, assuming office. So that it allows that window for correction.
Correct.
Okay. That was my reading of the case law too. I just want to make sure I'm correct.
Yes,
Thank
that's
you.
my understanding.
Thank you.
Thank you. Anything else from Mr. Musson? Okay. Chair recognizes Kim Thomas. Is Ms. Thomas or an attorney representing her present? Yes, please. And if you could state your name and spell it for the record for our court reporter, please.
Good morning.
Good morning.
Lisa Knapp, LISAMACK. I'm an attorney with Drexel and
Oh,
Andrus,
thanks.
and I represent Mayor Kim A. Thomas, Mayor of the City of Richmond Heights. The law director for the City of Richmond Heights is also in attendance this morning, Todd Hunt. On August 21st, Mayor Thomas filed with the Cuyahoga County Board of Elections a written protest of the candidacy of Alex D. Harper. The protest stems from the fact.
Thank you. Shall I begin again?
No, you can go.
Okay. Her protest stems from the fact that Alex Harper has 2 felony convictions in federal court. one in 2005 and another in 2011, both for bank robberies. On August 27th, 2025, Mayor Thomas filed a supplemental letter of protest against the candidacy of Alex D. Harper stemming from those felony convictions. Mayor Thomas is the executive head of the city of Richmond Heights under its charter. She is responsible for seeing that all laws and ordinances are enforced therein. On behalf of the citizens of Richmond Heights and on her own behalf, as a qualified elector of the city of Richmond Heights, she has presented her protest against the candidacy of Alex D. Harper for the office of councilperson at large for the city of Richmond Heights City Council. Mayor Thomas is requesting that Mr. Harper's name not be placed on the ballot for the general election to be held on November 4th, 2025. Because Alex Harper was convicted of federal felonies, he's not qualified to hold the office of councilperson at large. And because those federal felony convictions, because of them, he has also forfeited his privilege to circulate petitions for a candidate for public office. And the petition for candidacy that he submitted to the Board of Elections on behalf of his own candidacy is invalid. I would like to submit to the board certified copies of each of the plea agreements. I have submitted to the board certified copies of each of the plea agreements whereby Alex Harper pleaded guilty to federal felony offenses, and the judgment entries whereby he was sentenced to federal prison and supervised release. Included for each conviction is a copy of the federal court docket, which shows no entry indicating that either conviction has been overturned or annulled, or that Mr. Harper has been pardoned. I've also submitted copies of the applicable provisions of the Ohio Revised Code, an opinion of the Attorney General, the Ohio Attorney General, and case law to reference in making your determination of this protest. As set forth in the mayor's protest, because of his guilty pleas and conviction of federal felony offenses, Alex Harper forfeited his privilege to hold an office of honor, trust, or profit under the provisions of 296101A1. The office of councilperson at large for the city of Richmond Heights is an office of honor, trust, or profit. In addition, his felony convictions rendered Alex Harper, by operation of law, incompetent to circulate a declaration of candidacy and petition as set forth in Revised Code 2961.01B. Alex Harper was convicted of 2 federal felony offenses for bank robbery by force and violence. He was sentenced to 57 months prison time, 3 years supervised release for the first felony conviction, which was for committing 5 bank robberies. After his release, Harper again robbed National City Bank on June 11, 2011, and he was sentenced to 96 months in federal prison and 3 years supervised release. He served his sentences and supervised release, and his right to vote has been restored. However, he is incompetent to hold an office of honor, trust, or profit under Revised Code 296101A1. Under that provision, the privilege to hold such office may be restored if the conviction is reversed or annulled, which, to the best of my knowledge and belief and research, has not occurred. The privilege to hold such an office may also be restored by federal pardon. Again, I am not aware that there's been a federal pardon. There's no other provision by which the forfeited privilege to hold office may be restored. As indicated in the mayor's letter of protest, 2967.16, providing for the restoration of the privilege to hold office, does not apply to federal felony convictions. And I've included a copy of an Ohio Attorney General opinion on that topic for your reference. The other provision invalidating the candidacy of Alex Harper is set forth at 2961.01 3501B of the revised code. And that subsection provides that a person convicted of a federal felony is incompetent to circulate any declaration of candidacy and petition. The declaration of candidacy and petition that was submitted by Alex Harper for the office of councilperson at large for Richmond Heights is therefore invalid by operation of law. The Board of Elections is charged with the responsibility to review, examine, and certify the sufficiency and validity of petitions and nomination papers under Revised Code 3501-11K1. The Board of Elections shall accept any petition described in Revised Code 3501.38 unless there are grounds for the rejection of the petition or declaration of candidacy under Revised Code 3501.39. And one of the grounds for the rejection of a petition or declaration of candidacy is set forth in Revised Code 3501.39A4 and provides for rejection where the candidate's candidacy or petition violates the requirements of Chapter 3501 or 3513 of the Revised Code or any other requirements established by law. Importantly, that subsection provides for rejection on the grounds of both candidacy qualifications and petition requirements. And the Supreme Court of Ohio has held that a Board of Elections has the authority to review both the substantive issues of eligibility to hold office and the sufficiency of the petitions. And I would direct your attention to a case that's in your materials, State ex rel Shoemate versus Portage County Board of Elections, a 1992 Supreme Court case. And in that case, the court held that the Board of Elections had the authority and the duty to determine whether a candidate may lawfully be elected to the office he seeks and should not approve the candidacy if the substantive qualifications are not met. Alex Harper's candidacy violates 296101A1, prohibiting a person convicted of a felony to hold an office of honor, trust, and profit. He is substantively not qualified to hold office and is therefore ineligible to be a candidate for office. Alex Harper's petition and declaration of candidacy is also invalid because his felony conviction rendered him incompetent to circulate a declaration of candidacy and petition under 296101B. And he circulated and submitted all but 32 of the signatures, which is not enough to satisfy the City of Richmond Heights requirement of 150 signatures. Now, to address the timing of the submission of the supplemental letter of August 27th, 2025, as to the ground for rejection of his candidacy because of the invalidity of the petition, as to that additional ground, beyond the 74 deadline before the election, the Ohio Supreme Court has held that the purpose of the timing requirements that are set forth in Revised Code 3513.263 are not designed to render invalid an otherwise valid petition, nor to give validity to an invalid petition when not acted upon within the proper time. That case law is State ex rel Phillips versus Lorain County Board of Elections, a 2001 case. I've got copies of that here for your consideration.
Thank you. For the record, the first document will mark Exhibit A and we'll mark that one B, please. Thank you.
Thank you. I'd just like to say a few more words about that topic. The invalidity of the petition for candidacy of Alex Harper is mandated by operation of law. under 2961.01B. So that it is invalid regardless of any protest. The failure to submit a letter identifying that particular provision before that time does not render the petition valid. The letter of protest, the original letter of protest was submitted before the 74-day deadline. It identified the grounds for that protest as being the felony convictions of Alex D. Harper. So the incompetence of a convicted felon to circulate a petition for candidacy was apparent when the mayor filed the first protest letter bringing the felony to the board's attention. That was more than 74 days before the election. Mr. Harper submitted a response to the mayor's protest against his candidacy. And would you like me to address the mayor's responses or reply to his responses at this time, or would you like to give an opportunity for Mr. Harper to be heard first?
Yes, we'd like to hear, unless the board has some questions for Attorney Mack, please.
Okay. You heard our previous discussion on Ohio case law with respect to whether or not someone is disqualified whereupon being placed on the ballot versus winning the office and assuming the office. And I look at, I think it was Wolf versus Lorraine County Board of Elections, which clearly states a candidate generally need not qualify for the prospective office in order to run or be elected to the office, but it's when the office is assumed. So I did hear everything you said, but that really wasn't addressed. And there was a lot of case law to that effect. Do you have a comment on that, or?
No, he's obviously not competent to hold the office.
Right. But the distinction is the timing, whether this is the time to make that determination versus if he were to win.
Right. And I do acknowledge the distinction in the timing.
Thank you. I just wanted to be clear
Yes.
on that. Okay.
Yes.
Thank you, Ms. Sticken. Any other questions for Ms. Mack?
Could you, Ms. Mack, I'm affirming in the Phillips case that supports the position that the supplemental challenge, his being a circulator, is still a timely challenge in this scenario? Because if we have what your supplemental challenge is, that he is not an eligible circulator on his part
Yes.
petitions. Unless I misheard you, I thought you were referring to the Phillips versus Lorraine County Board case to say that this case from the Ohio Supreme Court stands for the proposition that this board should accept that particular challenge, even though there's some question about the timeliness of it.
Yes, that is exactly what I am urging, that this board consider that the case of State Ex Rel Phillips versus Lorraine County Board of Elections does provide support for that proposition because the timing requirements, as stated in that case, are not designed to render invalid an otherwise valid petition or to render valid an otherwise invalid petition. That is that the invalidity of the petition because of the incompetence of the petition circulator exists regardless of the protest against the candidacy.
Can you point to where in the case you're using to support that, the notion of timeliness, or that
Yeah.
it's not an abusive, it would be an abuse of our discretion to disregard the timeliness?
It's a good question.
Okay, that would be
On page,
paragraph, the paragraph on page 324. So it's the last page
Okay.
where you can see the paragraph that is marked 8 and 9.
Okay.
The head notes 8 and 9 are addressed there. And that's the section that I was quoting to you.
So in that case, Phillips challenged the board's decision not to set a hearing because of the timing?
It was, an elector sought a writ of prohibition in that case, a mandamus to prevent the County Board of Elections from placing a candidate's name on a general ballot for election to the office of council at large in the city of Lorraine.
Okay, thank you.
Lorraine, I believe. It was in Lorraine County.
Mhm.
Was that to do?
Yes, it
though, with
was.
When the hearing was set? Because the way I'm reading this, maybe the paragraph you pointed out, it almost seems like the board maybe didn't act to set the hearing or was some of the argument within that, the Phillips case. I guess you're saying our timing issue in terms of the note of the, essentially being before the deadline, you're trying to say that this holding this paragraph would allow us the discretion to not, to consider your
Yes.
supplement. Okay.
It does.
All right. But did that have to do with when the hearing was set or when the timing of, the distinction between the objections? Because actually, let me ask you this along those lines. You heard our legal advice with respect to this issue. There is the issue that was first before us, which is the one of competency qualification to serve the office. Then there's the secondary issue raised, which was the petitions themselves. So then this body has to distinguish, is there additional information when we're looking at petitions versus the actual convictions? So, your supplement, in other words, is that whole, difference and outside the notice before the deadline. That's, I guess, the question in my mind. Does that make sense?
You're asking whether there is supplemental information.
Well, I guess your position on that, because you heard our legal advice.
Yes, yes. And my position would be that the information that was needed for the
Right.
board to make a determination as to the validity of the petitions being circulated by this particular candidate was before you when the mayor submitted her bid protest letter on the 21st.
Okay.
So there's no additional information that would be necessary in order to make a determination that at that time, Alex Harper was incompetent to submit candidacy petitions.
But that would also require us to look at all the petitions. So that's, I guess, there would be some additional information and it's a different sort of issue we have to look at. That's where I'm stuck and that's what I'm trying to work out. Does that make sense?
Yes,
Okay, thank you.
yes.
Thank you, Ms. Sticken. Thank you, Ms. Mack. Any other questions for Ms. Mack? Okay, thank you, Ms. Mack. We'll come back to you. The chair recognizes our respondent, Mr. Alex Harper, or an attorney representing Mr. Harper. Please, sir. Mr. Harper, we're going to ask that you be sworn in by our court reporter, and then you spell and state your name for the record.
My name is Alex Harper.
Excuse me, we'll have you sworn in, and then we'll have you state your name. Thank you.
Here.
It's over here.
Oh,
solemnly swear or affirm that the testimony you are giving is true, whole truth,
yes.
Okay, sir, please state and spell your name, please.
Yes, my name is Alex Harper, Alex, last name Harper.
Thank you, sir. Floor is yours.
Yeah, and I'm gonna try to not get as emotional as I'm speaking because I feel like the issues are more so black and white. It's thank you very much. It's difficult being someone who was just as impacted over 20 years ago and still living with the over 1,200 collateral sanctions on a day-to-day basis. It's hard not to take personal when someone brings my current character into question based off a mistake that I made over 20 years ago. So, but I just wanted to states speak to that at first. But I also would like to acknowledge, thank you guys for your time in this matter. I did submit a response to the petition, to the original petition made, or original protest made, as well as an immediate response to the amendment. I received the amendment just a few days ago. I didn't get any level of advance notice that there would be an amendment to the protest. So when I was submitting documents for the board is when I found out about the additional amendment. So I tried to submit something toward that effect as well. I put something toward, and just listening to the hearing, listening to legal advice, it does seem that it may have been put forth after the deadline. But I did send you guys a motion or a 2010 opinion from the Attorney General on this, kind of giving more clarification to this point as well. Speaking to specifically the petition itself, and that an individual who has served his entire prison term and has not been placed on any post-release control sanctions, or an individual has been granted final release by the Adult Parole Authority, or individual who has completed the period of community control sanctions and a combination of community control sanctions that was imposed by the sentencing court. That a 2010 opinion says that if any one of those are met, that an individual is eligible to circulate petitions for candidates. So that was a 2001 opinion to the Ohio Board of Electors and members and general body. And I'm not going to be as long as Ms. Mack, but I'm going to speed up as well. The issue of holding office versus running for a candidacy, there is that window for correction between the time of election to the time of being sworn in, or sworn in in order to hold office. That does allow for any level of annulment, expungement, or pardon to still be obtained between now and actually taking office. And lastly, I don't want to take up too much of the board's time here today. But I would honestly just like to say that a judgment here also sets precedent that would exclude 15% of the Richmond Heights population from having even just the opportunity to participate in city government. Who I feel bad for is the citizens, who I feel bad for and concerned for are the citizens of Richmond Heights who have paid this taxpayer money to put these briefings together, again, seemingly prematurely and seemingly motive driven. I humbly accept whatever feedback or decision this body makes, and just want to thank you guys again for your time, and I'm willing to accept any questions.
Thank you, Mr. Mack. Board members, any questions for
Harper.
Mr. Harper? Yes.
I'm good. There's much to ask.
Thank you, sir.
Thank you.
Okay, board members, we have the information before us, and the chair will entertain motion. And what is your pleasure? Yes, ma'am. The chair recognizes Ms. Mack. Yes. Yes, please.
Thank you, and I will keep this brief. I just briefly wanted to say, in response to Alex Harper's response to the protest, he stated that Richmond Heights City Charter imposes no felony-related ineligibility. I just wanted to clarify that issue. While the charter is silent in that respect, state law does apply. The City of Richmond Heights is a charter municipality and is constitutionally empowered to enact its own home rule provisions with respect to its local elections. However, where it has not done so, and it has not done so in this particular area, the state provisions do apply.
Thank you, Ms. Mack.
Also,
Yes,
a couple other points. The 2010 opinion of the Attorney General that Mr. Harper referred to just now, stating that under revised code 2967.16, a convicted felon would have his right to hold office restored after the completion of the sentence and service of all post-conviction remedies, that applies only to state convictions. And it does not apply to federal convictions. The 1998 Ohio Attorney General opinion that you have in your hands addresses that issue. I would also like to say that this protest of Mr. Harper's candidacy is not the first. There was one that was, he filed for a candidacy for a petition for candidacy in 2021. There was a protest against that candidacy filed by then Mayor David Roche on the grounds that Mr. Harper was incompetent to circulate petitions. And the decision of the board at that time was to remove Alex, or not place his name upon the ballot for the election. So I would just like to say that he's been aware of this particular disability, if you will, and he's had a long time to address it, and he has not done so. Thank you.
Thank you. Mr. McCafferty?
Just a question on that pass. Oh, sorry. And that past case that you mentioned when petitions were rejected in, I forget the year. Do we know whether that protest was filed timely?
It was.
Yes, it was.
And also the issue, my recollection from that hearing, because I was on the board at that time, was also, I think it was the issue of him being on probation at the time of circulation. And also it was raised, I believe.
He was.
And so, I think we didn't need to necessarily go further because that was the issue. And then I think to my colleague's question, it was the issue before us. It was the sole issue before us, or the main issue.
Yes, that is correct.
All right. Thank you.
Thank you.
Board member, yes, sir. The chair, yes, please. The chair recognizes Mr. Harper.
Thank you very much. And I just want to, again, respond to the response. So the initial point she made about the charter of reverting back to home rule, the 1913 state constitutional home rule gives municipalities the ability to set their own requirements for candidacy. The only time home rule actually is enacted and put into effect is if there's nothing at all on the basis of candidacy in the charter. Richmond Heights has a clear outline for qualifications and requirements for candidacy. Therefore, reverting back to the 1913 home rule statute isn't necessarily required in this situation because Richmond Heights has a clear outline and requirements for their candidacy already. So there's no need to kind of revert back to home rule for this statute. And then also the point was brought up about my previously being here in front of the board. At that time, these same objections were raised. There were 5 objections raised at that time. The only one that the board felt that was valid or relevant at the time was the fact that I had not fulfilled, and to the requirements that I read off earlier, I had not fulfilled the obligations and requirements to complete my sentence up until that point. That was 4 years ago. Those requirements have been far met and exceeded. That time frame has been completed. And I not only have not been in any trouble since, but I've also received multiple commendations from public officials. I'm currently an adjunct professor at a local community college. I sit on multiple state and national boards as a national voting delegate on multiple national resolutions that are being enacted throughout the country. And I also put together a program where I'm helping individuals that are returning from prison to not make the mistakes I did prior. I'm sorry, ma'am. I'm sorry.
The chair recognizes Mrs. Stewart.
I want you to finish your sentence.
Yes, ma'am.
You are aware, though, make sure you understand that if the decision of this board is made in your favor, that Mayor Thomas's challenge to your holding office is not the actual issue before us, because we're adjudicating, or we're deciding here, not adjudicating.
Yes, ma'am.
Your candidacy.
Yes, ma'am.
That it still might mean that you can't hold office.
Yes,
You
ma'am.
don't, okay, make sure
Can
you
I-
understood that.
Do you mind if I speak to that point?
Absolutely.
I've also already taken the steps to obtain not only a pardon, but also expungements and sealments for all of the things in my backer. I guess the benefit of all of this, whatever your judgment is rendered, that I have started that process. I have reached out to multiple contacts. I'm also working with the CSU Post-Conviction Clinic and Case Western Reserve as well to get those things in place. Ideally, hopefully before I'm elected and take office
Right.
for the city of Richmond Heights.
Thank you.
Thank you, Mr. Harper. Thank you, members of the board. Okay, board, what is your pleasure?
With the, I guess I'd make a motion and make sure I'm wording this correctly. Would it be a motion to reject the protests to Mr. Harper's candidacy? Deny, yes. And I will make that motion.
Okay, the motion's before us.
Can I have clarification, Chair?
Yes, please.
Are we considering the August 21 filing and the August 27th filing to be one challenge?
We can, so I don't know, is it okay to speak to it or do I need a second to speak to the motion?
I'll second it so that it's on the floor and we can speak to
Okay,
it.
yeah, that's a good question because I think that would be why I'd make the motion and I'll give my reasons for that. Obviously, the first issue for me in this is the notice before the deadline, which I'll get to in a minute, and then the actual qualification to hold office, which I think we have discussed. And I think there's, with Ohio case law being pretty clear and relying on, I believe it was the Lorain County case, Wolf versus Lorain County Board of Elections. So I'd like to put that in the record as the basis for my decision. I think it's premature to trigger that given there could be a cure before his ability to hold office. And it's clear it's the qualification when you assume the office, not running. So for me, I feel like that's kind of settled at this point. So now to get to the second issue of notice before the deadline, and listening to information and sort of advice from our legal counsel as well. I view that as sort of the issue of whether or not he's qualified to hold the office separately and apart from the petition circulation. To me, those are different rabbit holes to go down, and one would involve even examining other petitions to see if he met the qualifications to be on the ballot. So, and I also think there's a deadline and notice to be provided for these kind of hearings, and that is a separate argument. So in my mind, that is the basis for my motion. And I do appreciate the arguments for counsel and my colleagues too, that this could be something maybe that isn't premature for us, or it's a little premature to review depending on how the election goes. But I would also note, I do see that as two distinct issues. And for me, that is why I'm making this motion at this time. Thank you.
I would then second the motion. I don't find that the state Exrell Phillips versus Lorain County Board elections makes, I find that the August 27th challenge is outside of the deadline and isn't bootstrapped in because it does involve different evidence, although the felony conviction is the basis for both challenges. So, and I don't find that the state Exrell Phillips versus Lorain County Board case actually cures that or really gives us the discretion not to uphold that requirement. So I would second Board Member Sticken's denial of the challenge submitted on August 21st, 2025, because eligibility to hold office is different from eligibility to be a candidate for the position.
Thank you, Ms. Stewart. Any other comments from the board? Okay, the motion is properly before us. All in favor? Aye. Aye.
Okay.
All opposed, same sign. The ayes have it. It is so ordered. Thank you all for being here today.
Thank you.
On to item number 10. We have a list of candidates, nonpartisan candidates for the November 4th, 2025 general election. And I move the certification of those candidates, nonpartisan candidates and write-ins for the November 4th, 2025 general election as submitted in our board packet. Second by Mr. McCafferty. All in favor? Aye. Aye. The ayes have it. And item 11, there's a list of remaining issues for the November 4th, 2025 general election as provided in our board packet. And I move the certification of those remaining issues for November 4th, 2025.
Chairman,
Yes.
if I may, oh, I'm sorry, a second.
Second, and then you have the floor. Thank you.
Yes, for the Cleveland Heights, the municipal issues. It says, shall the proposed First Amendment Charter of the City of Brooklyn, as
Oh,
reported.
Thank you. So we will note for the record, that will be changed. Shall the
Cleveland
proposed
Heights.
first amended charter for the city of Cleveland Heights?
Correct. As reported by
We
City
will
Council.
update the record. Thank you so much,
That's good.
Ms. Stewart. Be adopted.
Okay.
All right. With that necessary correction, the motion is before us. All in favor, aye. Aye, the ayes have it. And on to personnel. We accept the resignation of Mr. Brent Charnigo, Executive Assistant to Deputy Director Caliger, effective August 29th, 2025. All in favor, aye.
Aye.
The ayes have it. It is so ordered. And on to new business, and the chair recognizes Mr. Perlotti.
All right, I'm going to give a update on the September election and then pass the baton to Deputy Director Caliger for a November update, since we are officially running two elections at the same time. For September, this past Sunday, early in-person voting ended at 5. We did have good turnout for this election. Of course, we always want it to be more, but I believe we had 1,510 individuals come down and utilize early in-person voting in our new location for this cycle. When we look, we always deal with comparables. So when we go back to 2017 and 2021, we actually beat the 2017 number, which was 1242, but could not hit 2021, which was 3289. And I would attribute part of that to wasn't a citywide election in the city of Cleveland. It was basically half of the council seats, where we know in 2021, we had a mayoral primary for the city of Cleveland, which brought out more people. So staff did well. They figured out how to use the space. We have a couple changes, minor, that we'll make when we go into November, but that was a success. The vote by mail application deadline for this election for September was last Tuesday, and staff had processed 5,622 valid applications. They also processed just over 1,800 invalid applications, and that's primarily attributed to individuals submitting applications who aren't in the election. And that is something that we see when we have elections that aren't countywide. They were all notified that their application was invalid for the election. We sent back a letter to them. Through last Friday, we had 3,884 valid absentee ballots returned, and that's a 67% return rate, and that is poor. And so we hope that through today's mail, tomorrow's mail, Dropbox deliveries today, tomorrow. Dropbox is open until 7:30 p.m. Tomorrow, Election Day. That hopefully all those things combined, we get about another 1,000 ballots back, which is very doable. And because of the low numbers, that 1,000 ballots would get us something more respectable, like 85% plus, which would be closer to what we would expect or hope. So that is a shout out to everybody who has a vote by mail ballot sitting on their kitchen table or counter. Get it to us. It must be postmarked by today. So if you do go to your mailbox on the corner of your street, you want to look to see what the last pickup time is. You need to put it in that box prior to the last pickup time, because if it is after that last pickup time, it will not be postmarked timely. If any questions, actually go into the branch. That is a really good option. But if you're not able to do that, you can drive it down here to the board. The drop box doesn't close, open 24 hours a day, and it will be open until 7:30 p.m. on the 9th, as I had mentioned. Looking to what happened and the absentee, we use that to make some projections about what may happen on election day. At the start of this process, I had hoped for a 20% turnout for this election, always being optimistic, and now trying to be a little bit more realistic. I think maybe around 15% could be a more doable number. And I hope so. And for that to happen, I need those 1,000 ballots to come back, like I said, and I need about 23,000 people to show up to the polls tomorrow. And I think that is truly an attainable number, and I hope it does happen. As far as poll worker department, we have hired a full complement of poll workers, have trained them. We have 25 standby workers that are trained and ready to go in case we need to fill no-shows or emergency absences tomorrow. So we're in a good position there. And one of the things with this being our first election being conducted in this building, we have some firsts. We have a lot of firsts. One of the things is we're rolling out a new election day call center system. That's not necessarily because of a new building. That's because our old system really is not working where it needs to be. It was an in-house software that has done well, but it's come up to its point where we really can't patch it anymore. And also, come October, pursuant to Secretary of State directive, everything needs to operate on Windows 11, and that platform actually would not work. So this September election gives us an opportunity to utilize a new logging system in our call center operations. Now, it's born out of a system that we have been using for a while on a much smaller scale, and that's for our election response personnel who go to the polls on election day to help troubleshoot some issues that are going on at the polls. So it's been built out now to match our call center modules that we have, meaning there's an electronic poll book module, there's a voting equipment module, personnel outs modules, and building issues, supply issues, and other general issues. So we have all those things that were in our previous system that we brought over into this system. And all last week, our staff went to training on the system. There was 2 different versions. There's basically a super user, supervisor type training that some individuals had, and then there's your more basic end user system. So the training went really well. I want to give a shout out to Peter James for leading the implementation team and the people who worked with him to get this infrastructure set and ready. And then also a shout out to the poll worker department who conducted that training and did a really good job of getting our staff prepped for it. So we're excited for that deployment. This is something that is because of the building. We're also the poll worker staff. We're going to be deploying standby workers from this building. Previously, that was done at the Haley warehouse. That was a space issue. We have more space here, which is very good. And we can now have individuals park their cars here. They'll wait in this boardroom for their assignment to be sent out, and the poll worker department will give that all here. It makes it more efficient. The staff are all here. The management team can have more direct oversight on what's going on to help with emergent needs that may arise through that process. Also, the election support department, they have a first, and this also piggybacks with the ballot department in the Haley warehouse, which we have, right, been in that building. Has to do with sending all of our voting equipment materials to the polling locations where previously we sent individuals out to Berman's Moving and Storage, and now we're able to do all that from floor 5 and the other floors that we still have in the Haley warehouse. So election support worked with Berman's and deployed all voting booths, scanners, ballot bags, and other materials from the Haley warehouse, and we did not have to send staff out to Berman's. It is a more efficient process, gives us a little bit more time, not a lot, but as we know, a day is like a lifetime in this business, so all that helps, and it gives us the ability, which was really good, to work through some kinks in September so we can build upon that for November and make that even smoother. So that was a success. We will continue to work on developing best practices for our new processes. So everything we're doing a lot of times is adapting to the footprint, whether it's the changes in what is housed at Hallie and what we have here in this building. And staff is, they stepped up without any kind of hesitation. They welcomed the challenge. They embraced these things, and it kind of gets the juices flowing on how can we do things differently and make our operations even stronger. So I'm extremely thankful for their efforts and their attitudes as we learn to live in our new spaces. Want to remind everybody that, again, 5 o'clock yesterday was the close of early in-person voting. We are not a poll place today, and we are not a poll place tomorrow. You need to go to your assigned polling location in your neighborhood. We have provided all households in the election with the voter information guide. So if they have that, they can hold on to that to see where they need to go. They can always call us, and they can either talk to an operator or use our automated promise on our system, and they can always go to our website to find out where they need to vote. One of the biggest sources of confusion in this election, and more so for the city of Cleveland, is that it's not a Cleveland citywide election. So individuals really should come to our website if they have any kind of confusion as to if they're in the election or not. Mike West and Outreach created a document with other staff that we put up on our website that highlights who was in the election in Cleveland and who was not in the election in Cleveland. So we want to help and minimize people incorrectly going to the polls tomorrow. When they do go to the polls, they need to bring photo IDs, the same ID rules that have been in place now for multiple elections. So that is all new, and that voter information guide that we mail out is not voter ID. So it's a tool to help you get to where you need to be, but you do need to come with a valid, unexpired driver's license, state ID, passport, card, or booklet, federal, military IDs, those types of items, which are all on our website for people to review. Also, once we get past Election Day, the cure period is this Saturday for individuals who may vote provisional at the polling location or have a vote by mail ballot that there is a mismatched signature or missing piece of identification, and they need to come in and cure that. We will be open. They can do that, not the provisionals on Election Day, but the vote by mail. They can come in today, tomorrow, and through Saturday. And then for the provisionals, they can come in starting Wednesday through Saturday to cure those items. Also just want to remind individuals that we have 2 more board meetings that are associated with this election. We changed the dates of those meetings by a business day. Friday, September 19th is when we will consider our provisional ballots and look to see which are valid and should be open and which should remain closed. And then the following week on Thursday, September 25th, is when we will certify that election. And hopefully, for our sake, because we have November, there will be no automatic recounts, and we'll be actually able to put it to bed and be done with it. I do want to another change that we did, and this is something that is real positive, and I'm really proud of the staff to welcome this opportunity. We worked with an organization called Welcome House that helps individuals with different disabilities, and we partnered with them. In the last week of early in-person voting, we had 2 individuals each day who came from the organization with the job coach and helped the absentee department in the voting process. So they helped with greeting and handing out stickers, and it was just a real positive thing to work with this organization to give some of these individuals an opportunity to work and to participate when sometimes other people turn a blind eye to them. So it's something that we will continue to work with them and bring that into the November election. And it was really, really well received by the individuals coming down to vote during the process. So that's, I would say, a good feel-good story that we had at the Board of Elections. So that's the main things for the election. We are prepared and ready to go. And are there any questions relative to the September election?
Just have one question. You may not have the answer. With the absentee ballots that are returned, roughly how many would you guess need to be cured in some fashion? You may not know the answer.
I don't, so those would be right ballots that we receive that there is something that you could fix. And let me see, I can give you probably a ballpark. So of the actual ballots that came back that were challenged, we only had 9 that are challenged as of this point. That doesn't include anything that happens today or tomorrow. An ID not provided, signature not provided, ID was invalid. So those things we can, if they come in, they can fix those.
That's not many.
No, it's not. Now the application, that was a different story. That was much larger, but the actual ballots that went out and have come back with a deficiency, that is small. And what, I guess just to remind folks, what happens is when that actual ballot comes back and there's a deficiency, there's a Secretary of State form called the 11S that we send out right away to the voter, and it identifies what the issue is with that ID envelope. And what they can do is they can just provide it on that form. So for example, if you forget to put your last 4 of your SOCH, all you need to do is put the last 4 of the SOCH on the form, send it back to us, and we'll cure the ballot. You don't need to refill everything or for that. So again, that's something where they can send those forms in, but we need to have those by Saturday, or they can always come down and we'll work with the person, the individual, to see if we can cure their ballot.
Thank you, Director. Deputy Director?
Thank you. Back-to-back September and November elections are always tricky for our departments. Some processes need to be performed simultaneously, while other ones need to be teed up and ready to go after tomorrow's election. The ballot department has done the November data import for the ballot. They're currently proofing the candidates and issue language, as well as the precincts. They will have that done sometime next week, and it will definitely be finalized before Cuyahoga ballots go out on September 19th. The absentee department will start entering the vote-by-mail applications for the November election on September 16th, after they've completed the work for the September election. So Track My Ballot application on our website will not go live for November applications until after that date. And also, just as a reminder for voters, we don't start mailing out ballots for the November election until October 7th. So don't expect to receive any ballots prior to that date. For the registration department, certain registration cards and address updates that they receive, they cannot put into the live database until after certification. But what they do is they enter those registration cards into a voter hold module, and after certification, so they have it all teed up, and after certification, they'll be able to release those into the live database. And for the poll worker department, they have begun recruiting for the November election, but to avoid confusion, they've only been working in municipalities and poll locations that are outside of the September election. They have sent out email notices to workers who have worked in those areas in previous elections. And good to say, out of the 2,000 inquiries that they sent out, they had over 1,700 people who responded and says, yeah, they would like to work in the November election. So after tomorrow's election, they'll start scheduling them for training, as well as start recruiting for the areas that are in tomorrow's election. And finally, election support has locked down all the locations needed for the November election. We have received either signed contracts from those locations or firm verbal commitments for their availability on November 4th. After tomorrow's election, they'll get all those contracts finalized. So that concludes it.
Thank you. Any questions for
Yep.
Deputy Director Gallagher? On behalf of the board, we want to thank all of you for your work for tomorrow's election. And we know that we'll do what Cuyahoga does, have another successful election.
Good
And
job.
so the board definitely applauds your work. And I know personally the kind of work that you've done, and know that you're running parallel tracks here, to get past tomorrow, and then all of a sudden November 4th is upon you. But keep up the good work, and we commend our director and deputy director for their leadership and the management team and all of you. So have a good election. Try to get as much rest as you can, which I know is sparse, but move forward. The chair has not received any requests for public comment, and hearing none, we will go into recess.
Thank you.
Thank you. Have